So what I will do on this video podcast is to discuss the drafting of criminal statutes or those in the California Penal Code. Drafting criminal laws is an important undertaking for any bill drafter because obviously the consequences for those who violate these statutes can be extreme, and the courts strictly construe criminal or penal code statutes. As a result, those who draft criminal laws have to take a number of issues into consideration. There's some valuable guidance for drafting criminal or penal statutes from the Athabasca University in Canada, which runs a graduate diploma in legislative drafting program. And they suggest a number of factors to consider, such as ensuring that legislation does not violate any fundamental right or freedom that's guaranteed under the state or federal constitutions, as well as specific items such as guaranteeing a right to a fair hearing, restricting the seizure of an individual's property, limiting in clear language any enforcement authority, and of course, providing some review of prosecutorial conduct. So, what do criminal laws generally provide? Well, first, the offense is defined and is classified, for example, as a serious crime. Second, a level of culpability is provided. The third is generally a defense or defenses are specified. Fourth, the parties are defined. For example, those committing the offense versus those who were aiding and abetting the offender. And then other provisions might affect criminal procedure, evidence, even court jurisdiction. So several steps are suggested to be taken by the bill drafter when determining the content of a criminal or penal code statute. For example, is similar conduct already subject to existing law? Naturally, we wouldn't want any duplication or to create any sort of, double jeopardy problem for the statute. What conduct precisely is being prohibited? The prohibited criminal activity has to be clear so that individuals know what conduct is or is not a criminal offense. Should the mental element be expressly addressed? For example, is it a strict liability offense, or does it require some sort of mental state or mens rea? For example, intent, willfulness, recklessness, negligence. What is the maximum and perhaps minimum penalty for committing the offense? Is it a fine, imprisonment, both? Does that change for a second offense or a third offense? And then are there any special defenses allowed? For example, if reasonable care were exercised, is criminal liability still imposed? What about things like the age of the offender? Does duress or self-defense perhaps apply? Now, with this sort of information, there are obviously a number of drafting rules for criminal or penal statutes. And in general, these types of statutes have to contain three main elements: a clear statement of the prohibited conduct, a statement that engaging in that prohibited conduct is a criminal offense, it constitutes a criminal offense, and then the punishment that will be imposed for violating that criminal offense. So based upon the rules of someone's specific state, or obviously at the federal level as well, offenses can generally be expressed in one of three ways. Declaratory, a person who does X commits an offense. Conditionally, if a person does X, that person commits an offense. Or mandatory, a person is prohibiting from doing X, or that person commits an offense. Now, bill drafters are usually advised to expressly state that violating specific prohibited conduct constitutes a criminal offense, and then setting forth the penalty. The initial sentence is generally to begin with, for example, a person who does X, rather than using any person. Also, the present tense should be used in stating the elements of the criminal offense. In addition, bill drafters should clearly describe who the offender is and again, what behavior is prohibited. As a general rule, most criminal statutes simply refer to a person and focus more on the prohibited conduct. However, in some instances, as you might expect, a specific offender has to be defined in the statute. For example, a licensee or a corporation or the age or something of the person. Thereafter, the bill drafter has to prescribe the prohibited conduct. And here it's important to avoid overly broad or ambiguous terms. The language should provide certainty to those who would be affected by the prohibition. And the same rule applies to the mental element of the crime. While there is a general presumption that criminal offenses carry a mental element, it's best to clearly specify that in the statute. As a result, the drafter should provide a specific intent that is held by the offender. On the other hand, if the intent is to exclude, or the purpose of the statute is to exclude a mental element, then use appropriate words to make clear that that is the purpose. Criminal or penal code statutes often use terms to express a required mental state, such as willful or knowing. And then for strict liability offenses, they not only apply to individuals, but also at times to corporations as well. So this is not an exhaustive treatment, obviously, but some basic information to consider when drafting a criminal or penal statute.